in the Obergefell case, I would start out, I don't know how many people have had a chance to read through the 5 different opinions that the court issued, but I thought I'd start out by going through just some of the nuts and bolts of what exactly the decision, the majority opinion said, what the dissenters argued, and then take a step back and look at more of the implications for the court and for same-sex marriage and gay rights more generally. So, as Dean Burke said, the case has presented 2 questions. One was the constitutionality of bans on same-sex marriage, and the other was whether states are obligated to recognize marriages that had been performed in other states that did recognize same-sex marriage, even if that state did not. And with respect to the first question, the court held, yes, in fact, the right to same-sex marriage is a fundamental right protected by both the due process and the equal protection clauses of the 14th Amendment. And as a fundamental right, states would have to offer a very compelling justification to deny that right, and in these cases, according to the court, the justifications that the states put forward were not sufficient. And largely those justifications were focused around the purpose of marriage being for procreation and child rearing and forming lasting parent-child bonds. And as the Supreme Court and many other courts have pointed out over time, there's no clear indication that those sorts of goals are any different in same-sex marriage as they are in heterosexual marriages. So, given that bans on same-sex marriage were held to be unconstitutional in the first question, the court didn't have to reach any analysis of the second question, and the result is therefore that states have to recognize same-sex marriage on the same terms as they recognize heterosexual marriage, regardless of where those marriages were performed. So, with respect to the reasoning of the case, as I said, Justice Kennedy, who wrote the majority opinion, held that both the Due Process Clause and the Equal Protection Clause protect the right to same-sex marriage. And with respect to the Due Process Clause, he said that marriage generally is a fundamental right. And this is something that the court has held on several occasions in various different contexts. Initially with bans on interracial marriage, the court said those were not permissible because marriage is a fundamental right. And other restrictions on marriage, people who were incarcerated, people who had missed child support payments, that laws preventing those people from marrying were impermissible because marriage itself was a fundamental right. And here, the majority said marriage among same-sex couples, it's the same institution, we're just announcing that everyone has the right to access this institution of marriage on the same terms. And with respect to why marriage is a fundamental right and why it should apply across the board, Justice Kennedy pointed to sort of 4 principles that have come out of the court's marriage as a fundamental right line of cases. And those 4 points were that choosing a partner is an inherent element of individual autonomy, as it's part of the liberty that's protected by the 14th Amendment, that this is a special, unique relationship between 2 people that the state has chosen to honor, that it safeguards children and families, and that marriage as an institution is really a cornerstone of our social order. And denying same-sex couples the right to that institution demeans both them and their relationship in a way that the Constitution doesn't permit. With respect to the equal protection justification, it was not a traditional equal protection analysis. Normally you would expect the court to announce a level of scrutiny and decide whether or not these laws pass that scrutiny. Justice Kennedy did not announce a standard of review with respect to equal protection. He didn't say if he was performing a rational basis analysis or a strict scrutiny analysis. He did not have anything to say about whether gays and lesbians are a protected class of some kind, such that differentiations on that basis were going to be subject to heightened scrutiny. Instead, he said that there's this relationship between the Due Process Clause and the Equal Protection Clause, such that when you're dealing with a right that is a fundamental right under the Due Process Clause, that any distinctions that you make among groups with regard to access to that right is going to be subject to very stringent review by the court. So, in some ways, it's similar to saying fundamental rights are subject to strict scrutiny. But the way that Justice Kennedy talked about it, he sees this very close link and overlap between what fundamental rights are protected and what the government can do with respect to determining who can access those rights. So, there were 4 dissenting justices, each of whom wrote their own dissenting opinion, which is relatively unusual. Some of them joined one another's opinions, but each of them had their own dissent. The primary dissent was by the Chief Justice, and for the first time in his 10 years on the court, he announced his decision from the bench, his dissent from the bench, which is generally an indication of the vehemence with which the justice disagrees with the majority position. And then most of the dissents sort of struck the same theme, which was the Constitution doesn't have a definition of marriage. Therefore, this is something that should be decided by the democratic process, and by deciding on its own what marriage means, the Supreme Court is imposing its own preferences or its own views on what the Constitution should mean on the country, rather than allowing the democratic process to continue working out what marriage is going to mean in America. And as Justice Roberts put it, that he said the majority opinion at heart is really an argument that marriage is good for people, whether they're gay or not gay, and allowing them to marry will be good for society. And he said if I were a legislator, I would certainly consider that view as a matter of social policy. But as a judge, that's an indefensible basis on which to determine questions of constitutional law. And given that the definition of traditional marriage has lasted pretty much from time immemorial, his quote was, "Just who do we think we are as a court to impose this new meaning on this institution?" Justice Scalia, joined by Justice Thomas, spoke along very similar lines, but with a little bit more vitriol in some of his statements, and with traditional Justice Scalia diplomatic language. And he characterized the majority's opinion as a threat to American democracy, and said that allowing this select, highly unrepresentative panel of 9 justices decide this issue violates a principle even more fundamental than taxation without representation, that it was social transformation without representation. And with respect to Justice Kennedy's high-minded, relatively flowery rhetorical style in the majority opinion, Justice Scalia said that the Supreme Court of the United States has descended from the disciplined legal reasoning of John Marshall and Joseph Story to the mystical aphorisms of the fortune cookie. And that if he ever joined an opinion with this type of language in it, he would hide his head in a bag. So, not agreeing with the majority opinion here. and is concerned about the legitimacy of the court in being seen as imposing its own preferences on the country. Justice Thomas would have gone further, and he makes a broader argument about substantive due process rights generally, arguing that the Due Process Clause is not a basis for any substantive rights whatsoever, be it marriage, abortion, the right to decline medical treatment, and that what the 14th Amendment means when it protects liberty is it protects physical autonomy from government intrusion. And same-sex couples were not experiencing any government intrusion. Instead, they were demanding recognition by the government, and that's not what the 14th Amendment was meant to protect. And then finally, Justice Alito's opinion raised a couple other issues with regard to what the impact of this decision was going to be. And he raised some concerns about how it would affect individuals who had religious objections to same-sex marriage, and also questions about the way that people who continue to disapprove of same-sex marriage will be viewed, and worried that the Supreme Court's decision would allow people who disagreed with it to be characterized as bigots because of their position on this issue. Interestingly, none of the dissenting justices reached the second question and told us what they would have said about whether states are obligated to recognize marriages performed in other states. As I said, given what the majority opinion said, that it was sort of a moot issue, but had the dissenters won on that first question, they would have had to reach this second issue, but none of them told us how they would decide. So one thing that I think is very interesting is sort of a bigger picture issue about this opinion is it presents a really stark example of a disagreement about the role of the court that has really existed essentially since the country has existed. And this is the idea of what is the court's role in the evolution of society and the evolution of our understanding of rights and liberties. And Justice Kennedy made a very explicit argument for what's often referred to as the living Constitution, that the meaning of the Constitution can change and evolve as our society changes and evolves. And he said that the nature of injustice is that we may not always see it in our own times. The generations that wrote and ratified the Bill of Rights and the 14th Amendment did not presume to know the extent of freedom in all its dimensions. So they entrusted to future generations a charter, this Constitution, protecting the right of all persons to enjoy liberty as we learn its meaning. So very clearly envisioning a role for the court to determine what society believes to be the meaning of liberty over time, whereas Justice Scalia, in a sort of traditional originalist argument, said that when the 14th Amendment was ratified in 1868, every state limited marriage to one man and one woman, and no one doubted the constitutionality of doing so. That resolves these cases. So to him, the question goes no further than that, and this is a debate that we see play out on this court in many, many different contexts, but very starkly here. Very quickly, before we move to Q&A, the response to this decision has been generally relatively smooth. A lot of people sort of saw the writing on the wall, expected this decision to come down the way it did. And as of July 8th, 99.7% of the American population lived in counties where same-sex marriage licenses were available. So it was a relatively smooth transition, except in Texas, where some of you may have seen, following the decision, the Attorney General issued a legal opinion instructing county clerks that if they had religious objections to same-sex marriage, they were not obligated to issue same-sex marriage licenses. Some of those clerks have taken him at his word. One county clerk has resigned, saying that the laws that she had sworn to uphold and execute had been changed. And another county clerk has announced that she'll resist unlawful or federal state court encroachments on the prerogative of the people of Texas to protect natural marriage. So she's refusing to issue same-sex marriage licenses. Presumably, eventually someone will sue her. But so far, that hasn't happened. So the question of same-sex marriage has been finally settled by the Supreme Court. But of course, the battle itself will continue on a number of different fronts going forward. I'm happy to talk about those kinds of things in Q&A.